Good morning again. Welcome to a session of oral arguments before the 5th DCA. I'm Judge Jim Edwards. I'm joined by Judge Jay Cohen and Judge Meredith Sasso. We have one case on the docket this morning. The others have been dispensed with. There is another argument later on at 3 o'clock this afternoon. We've got case number 20-1593, Chris Garrity versus Maria Granier et al. For the appellant, we typically reserve 5 minutes for rebuttal. If you want something different, let us know. You can see your clock in one of the panels here on the screen. When you get to yellow, you are into your rebuttal. So if you see 4 minutes over there, that's all you have left. I'll try to give you a little heads up if you're in the middle of an argument and don't seem to be paying attention to the time, so that you'll have a few minutes left. So with that, counsel, you may proceed.
Thank you, Your Honor. May it please the court, counsel, I'm John Zielinski. I'm on behalf of the appellant, Chris Garrity. And this is an unusual appeal in a way, because there's been a concession at the end of the appellee's answer brief that the Gorsch decision is no longer controlling law in the state of Florida. And the issue that was appealed today is whether or not the notice, the technical defect that Judge Murphy found in the lower court pursuant to Florida Rule of Administrative Procedure 2.516 would prevent a determination on whether or not, or a substantive analysis on section 57-105.
Mr. Zielinski, let me ask this. There's been a recent amendment to Rule 1.080, and I'm wondering if, when we get done with all of this, we aren't right back where we started with in terms of how Gorsch ended up coming out. I'm curious if you could address that.
Your Honor, I have to be honest with you. I wasn't aware of that change in 1.080. I was looking at.
Well, I'll tell you what, it's significant and it directly impacts the issues in this case. I'm surprised that neither side had it in their briefs, but it's a very interesting amendment. And to me, it ends up being one of the most interesting issues in this case. So I guess you're not going to be able to talk about it.
No, Your Honor. And if
all right, then I don't know what you're going to talk about.
Yeah. In light of, I was of the understanding that in light of Wheaton and Wheaton, Abadi and Benino, that the law had changed and removed that.
Well, I can tell you that potentially, that amendment doesn't impact this case. At least arguably it doesn't impact this case because it's an effective date, but it would certainly seem to impact whatever opinion, if we were to write an opinion in this case, whatever opinion we would write would have to address that. And I was wondering how you think the court ought to address that issue. All right, go ahead and proceed then with whatever argument you'd like to make.
Thank you, Your Honor. And what I would say is if the 1.080 is not in place, then obviously our position would be that the Gorsch is overruled at this point, and the technical defect that was in place is now not an impediment to go forward with the substantive argument on the attorney's fees at the lower court level. We believe that once with the regression or going away from Gorsch, and the Florida Supreme Court moved in the direction of saying that the technical defect is not an impediment for us, that the only other issue is to have that entitlement hearing. Now, appellees raised Tipsy Coachman in an extensive argument in their brief, but we believe it's not available here because there's never been a substantive determination at the lower court level on whether or not attorney's fees were appropriate under 57-105. Florida Supreme Court did recognize Robertson that Tipsy Coachman is a appellate court option at times, but it has to have been fully developed. And here, it's not developed. There's the Robertson case itself is interesting because it overturned the Third District Court of Appeal, where there was not a factual determination at the lower court regards to the rule that the Third District Court of Appeal wanted to apply, despite the fact that that wasn't fleshed out in the trial court. So we think that the case needs to go back to the trial court at this point on the issue of whether or not fees are appropriate.
Mr. Liszewski, do you think that your request for attorney's fees on appeal complies with 9.410B?
I tried to follow it, Your Honor, and I believe it did. Again, the history of this case, and one of the interesting things, I think it's at R849, is testimony of Crystal Matthews, which basically is testimony of the decedent, saying that Stan Grenier was going to continue this case and challenge the appellant throughout. And that was why she had such a long meeting with these attorneys regarding executing that power of attorney. And I think that this is just a continuing tactic that has been employed throughout this case. We're 5 years after Hilda Grenier has passed, and we're still battling over, Rule 1.540 issues and these different things. It's just, the various items that were raised in the 1.540 were not in good faith, in our opinion, and the coachman here was not in good faith in light of the fact that there's never been a determination at the lower court. It's not applicable. Austin and Loretto, PA versus State Farm, which is cited by both sides, states at 229 Southern 3rd, 913, a trial court's findings on imposing attorney's fees as a sanction must be based upon substantial competent evidence presented to the court at the hearing on attorney's fees or otherwise before the court at the trial level. They quoted the Florida Supreme Court in Boca Berger. These findings cannot be made by the appellate court. And that's the issue. The appellees want the court to impose its will on an issue that is reserved for the trial court. What happened in, I believe, the Abadi case was that when it came to light that the Wheaton and Wheaton was going to apply, when the Supreme Court said the order to show cause against the petitioner in that case, the petitioner responded and said, we concede. And that's what should have been done. There was a concession here, but it came at the end of a 25-page brief, making this case much more difficult than it needed to be. The law is clear that there needed to be those findings at the lower court. And there's case law from both the first DCA that we quoted, as well as the fifth DCA, regards to tipsy coachman. In this case, or in the Featured Properties LLC versus BLKY, 65 Southern 3rd at 137, the First District Court of Appeals stated, sitting as an appellate court, we are precluded from making factual findings ourselves in the first instance. Relatedly, we cannot employ the tipsy coachman rule where a lower court has not made factual findings on an issue, and it would be inappropriate for an appellate court to do so. It is clear this appellate court cannot make those findings here. The Fifth District has also spoken on this issue in the Cal Atlantic Group Inc. versus Dow, 268 Southern 3rd, 265. At footnote 2, they state a trial court's ruling should be upheld if there's any legal basis in the record which supports the judgment, and the appellee should be permitted to exculpate any legal basis supporting the trial court's judgment. However, this court cannot employ the tipsy coachman rule where a lower court has not made factual findings on an issue, and it would be inappropriate for an appellate court to do so. Again, these are things that the appellees are seeking here, knowing that this is the law here in the Fifth District Court of Appeal. We feel that the history of the case warrants it, and we feel that it's warranted in the lower court. At least the lower court make a determination, and it's up to the judges here as to whether or not appellate attorney's fees are appropriate. And I'll leave that to the court to make a determination on that.
Right, do you have any other points you want to address, or does the panel have other questions? All right. Do you want to just reserve the rest for rebuttal, or it's your time, if you have more argument to make, go right ahead.
I think the argument would probably go towards more of the answer brief. And I think in this circumstance, we would just go ahead and reserve for rebuttal.
All right, that's fine. All right, counsel for appellees, you may proceed.
Thank you, Your Honor. May it please the court, my name is Meredith Smith and I represent the appellees. What is before the court is a fairly straightforward issue with a tortured past. The court made a ruling that the appellants were not entitled to attorney's fees.
No, they didn't. All they did, but that was based on a procedural ruling, not on a factual. And so I don't know, how far you're going to get with that. You conceded that Gorsh is no longer good law. I'm not understanding your argument at all on the tipsy coachman doctrine when the lower court made no factual findings whatsoever. And I don't see how you could possibly succeed on that. Let me ask you this.
Sure.
Are you familiar with the amendment to 1.080?
I am not, Your Honor, and I apologize for that. I was not aware.
A fair fight then.
I'm sorry?
A fair fight then.
Yes, Your Honor. Yes. So, I mean, I read through the tipsy coachman rules, and there's been cases in regards to that the court ruled upon, a different statute in Caraway, and we believe that it's analogous to that.
The legal issues you've got no factual determination, and the law is absolutely clear that if there are no factual findings, we cannot make those factual findings, which is what you've asked us to do in your brief. And it would be completely run contrary to the rule of, the position and the role of this court to make those factual determinations when the trial court hasn't done so. That's not our function. We're not a fact-finding court. We're a court of correction of error. And so I'm not speaking for the rest of the panel, but I can speak it for myself. That's a very unconvincing argument.
All right. We believe that the record does support that there was prior findings of fact within the record that would support the finding that the court denied the motion for attorney's fees and costs. I mean, the entire record was before the court at the time of the hearing. The notice, there was no due process issues. The whole court, it was before the court in regards to the entire petition. Their motion to strike.
Cite to the language in an order that's finding of fact.
There is no finding.
Give me a record site and a page site, anything.
No, there was no finding of fact in that order. That is correct, Your Honor. But the record does support that there were findings of fact that it can be based upon in previous orders, such as the order denying the motion to vacate.
Anything else you want to add?
No,
do you think Mr. Zielinski's motion for attorney's fees on appeal is a valid motion?
No,
not in terms of its merit, but in terms of procedurally.
Well, the first one definitely is not. The first one was filed before we even filed a brief. So, we've cited the two cases that it's completely technically deficient in regards to that. The second one, we believe it's not technically deficient. It's technically deficient as well, but also it's not. We don't believe that our argument is completely unmeritorious. We have a duty to argue and defend the trial court's order absent when we conceded the clear error, and we have tried to fulfill our duty to defend the trial court's order, and we're trying to do that. Does that answer your question? I'm sorry.
No, but I'm going to stop asking questions.
Go ahead. You have time. It's your time. So if you have further argument or anything you'd like to share with us, go right ahead.
Yeah, keep in mind, I'm only one vote.
Right,
Yeah.
thank you, yes. No, we think that that there is, even though the court did not make findings of fact in the specific order, that there were previous findings of fact within the order on the motion to vacate that this court can rely upon. We think that the appellant also confuses the scope of appeal versus the record on appeal, that we did not have to file a cross notice in regards to the prior orders to have the court review those orders. Instead,
Why would you not have to file a cross appeal to ask us to review error?
we're
Isn't
not
it
asked,
a party seeking reversal or seeking to a determination of a trial court's error to file a notice of appeal on that issue?
because we're not asking the court to reverse anything. We're not asking this court for relief for anything. We're just asking the court to affirm something. So we don't need to file a cross Miller versus Florida Inc. Guarantee Association, which is 200 Southern 3rd 200, specifically says it was not required to appeal the underlying logic supporting that result, nor could it have. So we don't need to file a cross appeal for the underlying orders.
That argument, didn't you request that this court remand for an evidentiary hearing because the trial court erred in failing to conduct one?
Only if it's going to remand. You know, it just points out that the court failed in that, you know, in that part of it, but that would only request the court to fulfill its appropriate duty on remand if it's going to do that. Yes, it pointed out that one specific error. But we weren't requesting the court to address, in the order on the motion to vacate, we were not, which is what I think the appellant was trying to get at, was that we were not cross appealing, or we're not seeking the court to appeal or provide relief in regards to that order. So we did not need to file any type of appeal on that order because we weren't seeking relief on that specific order. Instead, we were asking this court to look at the findings of fact in regards in that order, in regards to upholding this order specifically.
All right. Do you have further argument to make, or would you like to sum up? And
I'll sum up, Your Honor. In sum, we believe that this court can uphold the court's order denying the motion for attorney's fees and costs, and based upon the Tipsy Coachman rule, and there's nothing else further. Thank you, Your Honor.
all right. Thank you. Counsel for appellant.
Just briefly, going to Judge Cohen's inquiry regards to procedurally, it's possible the initial motion for attorney's fees that we filed, I did it in an abundance of caution to kind of, if there's a 57105 reason at the lower court, it extends into the appellate court, and that initial one, I would just concede, is probably not technically correct. The second one, though, I do believe I followed the rule, and I do believe that one is technically correct, and that is obviously for the court to make its determination. And then as to, I had an opportunity to take a look at 1080. Again, that is after this case, so this case needs to be decided as to the notice and the law that was applicable here.
Yeah, I realize that, Mr. Zielinski, but my question really went to, given that amendment, do we not necessarily in terms of how this case gets resolved, but ultimately do we end up right back where we started from in the Gorsh case?
It is very possible, and it's not for me to make that decision, but I don't think it impacts this case because it wasn't there at the time of this notice. And we would just ask the court to reverse the two orders, the January 2019, the June 2020, remand the case back to the trial court for that determination on attorney's fees.
All right, thank you. Any other questions from the panel?
Yeah, I just make this observation that it's a shame to see a family expending funds the way that this is going. It's your siblings are the longest relationship that you have typically over the course of a life, and to see a family torn apart like this is just it's a sad thing to see.
Right. And on that note, we will be in adjournment. Thank you very much, counsel.
Thank you, Your Honor.